Good morning. Welcome to the First District Court of Appeals. We have only one case for argument today. There are 4 cases that were submitted. The case up for argument today is In Re JT, case numbers C22-0609, 610, 611, and 612. I have for the appellant, Mr. Andrew, is it Hucklefinch? Good morning. And for the appellee, the state of Ohio, Mr. Sean Donovan. Good morning. All right, Mr. Hucklefinch, would you like to reserve some time for rebuttal?
Yes, Your Honor, I'd like to reserve 4 minutes.
4 minutes, and I will use the lights on the podium to let you know the yellow light will come up when you have about a minute left of your first part of your time.
Thank you, Your Honor.
All right, whenever you're ready.
May it please the Court, my name is Andrew Hockela-Finch with the Hamilton County Public Defender's Office on behalf of defendant appellant JT. Police lacked reasonable and articulable suspicion that criminal activity was afoot to justify a Terry stop in this case. Due to the gap in time between when the alleged shooting happened and the investigatory stop, the lack of personal observation and knowledge of the officers regarding this alleged criminal activity, and the fact that JT and the other 2 teenagers who were stopped were not engaged in any suspicious behavior or suspected of engaging in criminal activity when the investigatory stop occurred.
Can we take into account the fact that JT continued walking when he was asked to stop?
Your Honor, it's our opinion that when the police asked the other individual in the red hoodie and the blue jeans to stop, he specifically pointed to that individual. JT was simply walking down the street and continued to walk, and as soon as the officers acknowledged JT and told him to stop, he stopped and came back to the police cruiser. So we would argue that he wasn't engaged in any suspicious behavior, he was just walking down the street, and when he was commanded by police to come back to the cruiser, he immediately did so.
Do we know what time of day this stop occurred?
This stop occurred around 3 p.m., which was shortly after the dismissal of Dawn Community High School, which was nearby.
How close by was that?
It wasn't established at trial, Your Honor. In every Terry stop case, the court has to look at the totality of the circumstances to determine if the stop was justified. And 2 recent cases in Ohio, one State v. Harrison from the Ohio Supreme Court and State v. Henson from this court, are illustrated for the case at hand. In Harrison, the Ohio Supreme Court justified a Terry stop because police personally heard gunshots, went to where they believed the gunshots occurred from, and it only took them about 30 to 60 seconds to arrive on scene. And when they arrived on scene, they encountered Hairston, who was alone in a crosswalk. In comparison, in State v. Henson with the First District, police had received a third-party tip via ShotSpotter and were given a general radius of where shots could have originated from, and it took them several minutes to arrive on scene. When they arrived on scene, Henson was there with 3 children. This court ruled that that was not enough to justify Terry's stop, and we believe that the case at hand here is analogous to Henson. Police did not personally observe this shooting. It had happened an unknown number of days prior. They had no personal observation or knowledge of this shooting. It took them several minutes to arrive at a gas station looking for an individual with a red hoodie and jeans, and when they arrived at that gas station, there was no one there. They continued their patrol and came across the 3 teenagers, one wearing red hoodie and jeans, and stopped them.
Why do they have to have personally observed or heard the shots? I mean, why couldn't somebody have called in, shots fired, and then they just show up in that location?
It's not a hard and fast requirement, but the court does look at that when it comes to analysis.
But why is that important for them to personally hear the shots?
In order to justify analyze whether the cops had reasonable suspicion that criminal activity was afoot. And Harrison was important because the cops personally observed the gunshots and went to the location where they believed the gunshots occurred. In Henson, it was important that it was a ShotSpotter tip, and there was no specific information about where the shots came from or who fired the shots. In this court determining that there was no justification for the Terry stop in that case.
It seemed like one thing that was really important in the proceeding below were these two pictures that supposedly, I guess, came from the day of the shooting that depict, in one image, a single teenager wearing a red hoodie with a gun, and then in another image, a group of teenagers. Do we have any idea where these images came from? Can we actually trace them to the shooting, or are these just internet stock photos? Like, do we have any idea of where this evidence actually originated?
The testimony and evidence at trial was that Officer Delk, who was not one of the patrol officers who was investigating the shooting, had received these still photographs from a security camera and sent the pictures to Officers Loading and Merritt, who were the patrol officers. But that is as far as the testimony and evidence goes regarding those still photographs.
And
No.
so these were their comparison point? These were the people that they were looking for?
Yes, Your Honor, they were specifically looking for an individual in a red hoodie and blue jeans.
No, my recollection was that there was a videotape of a shooting that occurred in a church parking lot. The shooter was wearing a red hoodie, and he was either shooting in a car or an individual. And I'm getting to the point of this now. The pastor of that particular church was working with Officer Delk and provided him a still photograph of the videotape taken at the church. Am I understanding that correctly?
That was, yes, correct. That was according to Officer Loading's testimony, but neither Officer Delk nor the pastor testified at the suppression hearing.
Right, but that was the information that was provided to the two arresting officers from Lieutenant Delk or Officer Delk.
Correct, Your Honor.
And it's my further understanding that this pastor happened to be driving past the Shell station at Harrison and McHenry and spotted what he believed to be individuals matching the description of the shooters or the shooter on that particular day. And these kids were stopped about a block away near Brackenwoods or on Brackenwoods Corridor Lane, whatever it's called. Am I correct in that?
That's correct, Your Honor. However, Officer Loading and Merritt, as well as Delk, could not, there was no identifiable faces, names, or ages of the individuals in the photograph.
Because it's my understanding they were looking at a photograph that they had on their phone that Delk had sent them, and, it's a little photograph, right?
Correct, Your Honor. But they had printed it out at trial, and Officer Loading testified he could not tell face, name, or ages.
All right, and you're not disputing that this pastor is an unreliable citizen informant, are you?
There was just no testimony or evidence to establish the authenticity of it. It was a suppression hearing, so hearsay was allowed in.
Right. Okay.
So we have no indication of what exactly why the pastor thought these were the same people that were engaged in the shooting, do we?
No, Your Honor.
But the testimony was from the officer that the reason why he stopped the group of kids was because of the red sweater or sweatshirt that was worn by one of them.
Correct, Your Honor.
Okay.
Now, the state has argued that the still photograph eliminates the need for contemporaneous response from the police between the alleged incident and the Terry stop. This court in 2014 decided a similar case in NRA MP in which a detective had been investigating a shooting that had happened days earlier, stopped a youth who was wearing baggy clothes and acting suspicious around police cars. And this court ruled and clearly stated that there has to be suspicion of current criminal activity in order to justify a Terry stop. Now, while the detective may have a hunch or may have a reason to suspect that child participated in a shooting days prior, that there has to be a present suspicion of criminal activity in order to justify a Terry stop. The same thing applies here. The police were investigating a shooting that happened days prior. We don't even know when exactly it happened. But when they came across these three teenagers walking down the street, there was no suspicious behavior and no suspicion that they were presently engaged in criminal activity.
I'm not understanding that exactly. So if they're investigating a crime that occurred days earlier, you're saying that they would have to be engaged in some other current different crime in order to get stopped?
Or they would have to be engaged in suspicious behavior, because the state's argument here is that someone wearing a red sweatshirt and jeans could be the justification to stop anyone walking down the street wearing a red sweatshirt and jeans. There has to be some sort of suspicious behavior. There has to be something else to tie in those individuals to the past.
What about a very distinctive look? I mean, a crime was committed days earlier and the person stopped, has I don't know if a red sweatshirt qualifies, but a very distinctive look. Couldn't they then stop the person to inquire about the crime that occurred days before?
I don't believe a distinctive look would be enough. I believe there would have to be some tangible link between the investigation, who they're looking for, and why they would justify a warrantless stop and search of an individual on the street.
Because the individual matched a picture from a crime that occurred days before.
We don't have a distinctive look here, Your Honor, and I'm not sure what would constitute a distinctive look, but here there was no faces. They couldn't determine ages. They didn't know names. They didn't know anyone in these photographs.
Counsel, even if these police officers went looking for the clothing, and we were to assume that that was in some sense reasonable, if the clothing on these three individuals walking down the street does not match the clothing in the picture, is their suspicion dispelled at that point?
I don't believe the only thing the police had to go on in this case was the generic clothing. If there's no match with the clothing, there's no reason to stop. And even with the generic clothing, we don't believe there's justification to stop because there was nothing unique or special about this clothing.
Well, let me ask you this, sir. My understanding was, at least based on the transcript, was that the officer's only purpose in stopping these three was to just identify who they were, and that was coupled with the fact that Officer Delk advised the two officers that these kids may be armed. All right, so it was a stop just to see who they were, and given the fact that Delk told them they may have a gun, you're saying it's unreasonable to pat them down for their officer safety?
Well, Officer Doug was not on the scene. He didn't
Well, but that's what he told the other officers, whether it's true or not. Do you understand what I'm saying? That's the information they had in their head. They said, well, we don't know who these kids are. We're trying to figure it out. They may be involved. They may not. They were going to stop them to ID them. And Delk said, I don't know what he said actually, but be careful. They may have a gun. So you're saying it's unreasonable, given that information, for the officers to pat these three kids down?
That is the state trying to justify a Terry stop after the fact by stopping and questioning and then saying they would suspect that these individuals would carry a gun. But you have to have the reasonable and articulable suspicion before you initiate the Terry stop. And Officer Delk just saying that these individuals may have a gun, he was not on scene. He did not identify these people. And so Officer Delk saying that the possible suspects for a shooting that occurred days prior would not give justification for the police to stop three random teenagers.
But isn't that part of the calculus that goes through an officer's mind when determining whether or not to pat somebody down? All the information, just say it's all false. Say everything's false. The minister didn't see them at the gas station. Delk didn't tell them that they may have a gun. Doesn't that just go into the calculus that's going through the officer's mind to determine whether a pat-down search is appropriate?
Under that reasoning, Your Honor, we believe that it would stretch the Constitution, Terry stop, beyond the limits of the Constitution, because then the police would be able to stop anyone under the fear that they would be carrying a firearm or suspected of criminal activity. But for the Terry stop, there's specific requirements here under the Constitution in order to do a warrantless stop and search.
And you're way over your initial time. That's okay. We asked you a lot of questions. I'll reserve your time for rebuttal.
Thank you, Your Honor.
Thank you. Mr. Donovan.
Morning, Ernest.
Good morning.
I'd like to start with an important distinction, that the report of the individuals that they were, the two officers, Officer Loading, the other officer that responded to the area, wasn't looking for one individual matching the description. The report was that 3 individuals, here's a picture, 3 individuals wearing the same clothing that they were wearing in the shooting incident were seen at the Shell station. So it wasn't just that they were looking for the red hoodie. It was 3 people. And the fact that you have in company with it takes out some of, you're saying that it's 3 random individuals. It's not 3 random individuals. This was a targeted stop of 3 people that they had descriptions of. They were together at the shooting incident. Now they're together just around the corner of the Shell station. So it wasn't, they went patrolling all around the neighborhood and eventually found them right around the corner from where they were reported, where the pastor said that they would find them. They find these 3 individuals.
How long ago, before they were stopped, was the shooting?
It is undetermined. It was not something, it was some, I believe it said earlier in the week was the closest that we had.
Do we know what day, like what day of the week they were stopped?
No, ma'am, I don't believe that. I don't believe there was testimony as to what specific day of the week it was. There was the date that was put in, and so I could go back and I could take a look at the calendar and say, oh, that was a Saturday, that was a Tuesday. But that was not specifically testified to, and I think that would go into the cross-examination about the Doane School and the fact that we don't know how far away that school was. There was no indication that there were any others high school age students around in that area, that these were 3 individuals that were part of a crowd or something like that. No, we don't know what specific day or the proximity.
But isn't the fact that it, clearly was days before, isn't that a crucial piece of the puzzle here when we're looking at totality of the circumstances of whether you can stop these people?
I think that it is absolutely something that goes into it, but I would disagree with counsel's position that there has to be, they have to observe current behavior that is suspicious. If you're looking for Bonnie and Clyde, and you see Bonnie and Clyde, but they're just, walking out of a candy store, they're not doing anything wrong, well, you still have reasonable suspicion to believe that they have previously engaged in criminal activity, and you can investigate that. And that's what I believe that the case.
Counsel, can you help me understand exactly what you're saying here? No one said that these were the exact same 3 people that were in the shooting. Instead, what came in was a tip that it might be based on the clothing that they were wearing. And if you compare the clothing that they had on, and in particular that critical red hoodie, it is absolutely not the same red hoodie from the photo. The red hoodie from the photo has a very large white Nike logo on the front of it, and the hoodie that the child is wearing in the body-worn camera video does not have that white Nike logo. It's very visible. So the clothing is not the same. This could be any 3 people. So how is it critical that there are 3 people walking down the street? There could be any 3 people walking down the street. Can you help me understand what you mean?
Yes, ma'am. I don't believe the distinction on the Nike logo was a particular point of contention, I believe, as was being discussed, that while it was a blow-up of a still photograph that was admitted into evidence, that the officers on the scene who made the stop were looking at it on their cell phone. So I don't know that distinction was, I don't believe that was made at the time, that it wasn't the same red hoodie. I would have to review the transcript again, but I don't believe that distinction was made. I understand the court's position in reviewing the blow-up and everything like that, but I don't believe that was made. I do believe that there was also testimony that the jacket that this particular defendant was wearing was also distinctive, and so you have.
Well, you mentioned that in your brief, but I looked at the record and I don't believe there was testimony from the officer about the jacket being distinctive. I think that was an argument that was made by the prosecutor after the fact. that the jacket was distinctive.
If I made a factual error, I would have to go back.
Because I was
to-
interested,
to-
I was interested in that point in your brief. And that was a major point that you made, was that the defendant in this case had the same jacket on as the person in the photograph. And I was just I went back to the transcript, and I don't recall the officer testifying to that. I thought he said that he stopped the kids because of the red sweatshirt.
My understanding, and I can refer back to the transcript, and I can certainly supplement, but I believe that I cited to the officer's testimony in it was that the officer said that there was a report that 3 individuals, and that the 3 individuals were wearing the same clothing as in the picture.
Yeah, he did say that. He
Okay.
did say that. But as far as this distinctive jacket that the defendant in this case was wearing, I think that all came out later on with argument by the prosecutor. I don't think that the officer was talking. To me, I felt like the entire thing focused on this red sweatshirt.
I believe that is one of the primary focuses, and I'm caught off guard by that in terms of I wouldn't imagine I would have cited to, one, would have made that without citing to officer testimony. I don't dispute, I would have to go back and review the record in terms of the distinctive nature of his individual jacket. I will, for purposes of this, I will ignore that fact in the remainder of my discussion. I don't doubt the court. My practice would be never to rely on something in argument. So, anyway, moving on from that, the testimony was that Officer Delk said that the pastor said 3 individuals involved in the shooting are at the Shell station. The photograph was sent over. Officer Loading said 3 individuals wearing clothing that matches that. I believe that there was testimony as to that. 3 individuals matching that. The fact that you have 3, I think, negates some of the discrepancies in individual and would go to the reasonableness of the officer's position. Yes, if we blow it up and look at it more closely, then I believe that there's any testimony the officers did, and it is ultimately determined that it's not the same red hoodie. Whether or not it was reasonable that we have 3 individuals wearing clothing that matches the same, whether it's the exact same clothing or not.
Are we talking about distinctive clothing or just the color of the clothing? 3 individuals wearing the same color clothing?
I said that I wouldn't rely on my distinctive statement, so I can only say that the officer testified that the 3 individuals, the clothing that they were wearing at the time of his stop near the Shell station, matched the clothing that they were wearing in the still photograph that he was presented. That was his view of looking at the photo on his phone. If ultimately that turns out that it wasn't the same, I think that goes to what Judge Winkler was asking about in terms of if there is inaccuracy in the information that's portrayed to that officer, how does that impact the reasonableness of his actions? And he can only act based on the information, the totality of the information that he has before him. And the information that he had before him is 3 individuals, this clothing matches, we believe that they might still be armed, and they're together.
But this takes me back to the temporal issue because, looking at the Hairston case, came out of the Supreme Court in 2019, I'm sure you're familiar with.
Yes,
and that's where shots were fired, and police heard it. They see one person standing there, and they stop him and they frisk him. And the majority opinion actually said that the most important considerations here are that the stop occurred very close in time to the gunshots, and Hairston was the only person in the area from which the shots emanated. So clearly that temporal proximity was what really kind of sealed the deal in that case, and we don't have that here.
No, ma'am, but I would distinguish it by saying that the temporal connection in that one is you're stopping a random individual who you have no other information as to any connection. The only connection is that they're right at that location where the shots are fired. That's the only thing that goes towards identifying that individual. That's not the case that we have in the stop here. In the case that we have in the stop here, it was specific individuals. These 3 individuals that are near this gas station who are wearing this clothing, everything like that, we believe that they're involved. These
Yeah, but days later.
Yes, ma'am, I understand, but well, the distinction that I'm making is that in Harrison, the temporal connection, and I don't argue, and I didn't argue in my brief. I said that the more time that passes, that is certainly taken into the calculus of the computation as to how much weight should be given to that. But it is not definitive, as counsel says, that because it wasn't within 5 minutes or 10 minutes and that it was a day earlier, that right there ends the analysis. It doesn't, because what we have is witness to the shooting, an identification of these 3 individuals as being involved in that shooting, and that then bolsters the timing. If what they had was that the officers showed up at the church 2 days later and, hey, there's somebody here, no, there's no reasonable
Isn't that stretching the testimony a little bit, though? I mean, the officer testified that he was assuming the tip came from the pastor. We didn't actually have testimony that the tip affirmatively came from the pastor.
My understanding, my recollection is that Officer Loading said Delk told him the pastor said that these 3 individuals are at the Shell station, go find them. And here's a picture taken from the security cam footage. So I believe that Officer Loading specifically said that the pastor told Officer Delk that those 3 individuals were there. I don't have the citation to the record before me. I can certainly grab my brief and find that. But I believe that there was testimony that is the source of that information. Now, granted, it's hearsay, but as counsel acknowledged, hearsay is permissible in the motion to suppress. And Officer Loading said, Officer Delk told me, the pastor told him. I get it at trial. We'd need to bring in the pastor. At trial, we'd need to bring in Officer Delk to make that connection. But we didn't end up at trial. And in a motion to suppress, that's sufficient to establish that the pastor told Officer Delk, and Officer Delk then told Officer Loading. I've gotten a bit far afield on some of the things that I wanted to discuss. One of the things that I mentioned in the brief that I did want to put in here in terms of the, or actually, no, I'm going to go back to, I believe it was your very first question, Judge, about the walking away. Absolutely. There's no testimony, I don't believe. Now, I've been questioned on some of my citations to the record, but I believe that the officer said, I flagged the 3 to stop. There's nothing that said that I want you to stop, and you just kept walking. Hey guys, need to talk to you. Stop. The other 2 knew very well that it was. The fact that the defendant kept walking, I believe absolutely is something that can go into the calculus, that can go into the totality of the circumstances that led the officer to believe that, yeah, he's continuing on.
But then we have to determine whether he could ask him to stop in the first place?
That's also, but that's at the heart.
That's the first step.
This.
Whether
Absolutely.
he continued to walk after he was told to stop, the question is, was the stop good?
Whether he had the authority to ask him to stop in the first place.
Right. So I don't know how that would come into the calculus if you're determining, is the stop good?
We can stop our analysis at the time of the stop. I believe that goes into the decision as to whether to pat down this individual, and whether the automatic companion rule that we discussed is that if you're looking for somebody who might have a gun, you can search the person that you find with them.
But isn't
and
the
tracking them.
only question in this case whether the stop was good? Because clearly, if they're considered to be armed and dangerous, if the stop's good, you can pat them down.
I would agree with you, Your Honor. However, the argument was made that there wasn't an additional independent belief that this particular person, that JT had the gun, that it was specific to them. So that argument was raised by counsel in their brief that there needed to be independent belief that he specifically might have a gun.
That would be if the stop was good, right? Because if we say, yes, the stop's good, then the defense is saying, yeah, maybe, if you say the stop's good, but then they couldn't pat him down, right?
I agree that if the stop is
Okay.
good, they have the right to frisk them, and there doesn't need to be any independent analysis. However, that's not the argument that was raised and has been made, that there needs to be a specific belief as to this individual
In order to pat him down.
in order to pat him down
Right.
after the stop. So that's why I was addressing that. It's one of the things that I believe, I'm not going to say that the trial court found that, because I can't specifically pull up that section. But it's the totality of the circumstances of everything that goes into it. And one of the arguments was that there was no reasonable basis to believe that he was engaged in anything. And whether the officer had authority to ask them to stop, I think goes into his continuing to walk. So I don't believe that it's a crucial issue. It was a question that Judge Kinsley had raised, and I wanted to address.
Let me ask you, you mentioned, I'll just call it the companion rule out of the 8th District. And has that ever been tested? I shepherdized, I couldn't find anything other than 8th District cases, but has that ever been tested by the Ohio Supreme Court or any other court?
I don't believe so. The logic, however, is sound that if you have, I believe that there's an analogy to removing individuals from a vehicle during in a traffic stop situation, that the officers are allowed to pat down those individuals that are in connection because they're going to be in close proximity to the officers. And this goes to the reference in that the trial court made to a dissenting opinion, that when you're talking, that's heightened when you're talking about an investigation into a crime of violence. And so would it be reasonable to mandate that in this situation, the officer should have just let him keep walking based on all the information that they have? There was involvement in a shooting incident, being with the individual that they believed was there, and to turn your back. There's no reasonable basis to believe that he has a gun, and I don't think that we can expect that of officers. And I think that it was reasonable for the officers to believe, and for their safety, to pat down all three during the course of this investigation. I'm sure that I am well over.
You are, but we asked you a lot of questions, so thank you.
Thank you, ma'am.
Mr. Hackliff, you have your 4-minute rebuttal time.
Thank you, Your Honor. Just briefly, I'd like to go over the argument the state uses for the automatic companion rule. As we've talked about, that's out of the 8th District, and that relies upon the same totality of the circumstances. And in that case in particular, a shooting had occurred and the officers arrived within minutes. Eyewitness to the shooting gave a detailed description, and that's what immediately led officers to encounter that individual, and as well as DS. And DS and that individual had displayed suspicious behavior and refused police officers' commands. Here, the crux of it is that the state is asking the court to justify a Terry stop off of a still photograph from a number of days prior based off of generic clothing. There's no way or reason to assume that the same people who committed the alleged shooting would be wearing the exact same clothes a number of days later. So we just believe that the distance between the shooting and the photograph used to stop the three teenagers in this case are too tenuous to justify a Terry stop, and we would ask this court to grant the motion to suppress. Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Thank you.